Hall, did you listen?
I'd like to say that after the public hearing on the rule, the court was faced with two options with regard to 802006-08. The court could either have retained that order as adopted on the emergency basis, or the court could amend the order. In either case, the court's decision was required to be documented by a recorded vote of the court, and that is per AO 1997-11B3.
I think
I
we've
wasn't on the court at the time.
Right.
And if someone would show me that there is a documented vote, a documented recorded vote of this court, that would be very beneficial
Well,
to me.
Justice Hathaway, you sound exactly like the people whom Justice Corrigan and I used to deal with in the United States Attorney's Office, who insisted they didn't have to pay taxes because the 16th Amendment was improperly adopted 100 years earlier.
Well,
This has been
Justice
on the law
Martin, you
books for
sound
years.
exactly like my children when they were in kindergarten.
With all due respect, earlier in today's proceeding, we discussed why there wasn't any need for another vote after an emergency order is passed. It is not anywhere in our rules. I believe that we do know why Justice Weaver wants this rule eradicated now, and that is she wants to kill this order retroactively and act as if it never existed because she broke the rule. This is a subject of a recent referral of her to the Judicial Tenure Commission, and what she is doing today is part of an attempted cover-up, plain and simple. She wants to prevent any attempt to enforce this rule against her. Administrative Order 2006-8 codified a practice that our court and every single appellate court in this nation has always followed. It is a simple rule. When appellate judges decide cases, we need to communicate openly and frankly with one another, and accordingly, we must protect the confidentiality of our deliberations. This court always followed this time-honored practice as an unwritten tradition since its founding, because one justice, and that would be Justice Weaver, decided that she is not required to keep our deliberations confidential. In 2006, we adopted such an order on an emergency basis. We held a public hearing to see whether the rule should be retained or the rule should be amended, after which the rule was not changed in any way. It is an effective rule today. Until today, as Justice Markman just pointed out, for the past 3.5 years, there has been no effort to change this rule until Justice Weaver broke it. Justice Weaver has a direct personal interest in proposing this rule change. Robert's Rules of Order states that people should not vote on matters in which they have a direct personal interest. It is often said that the cover-up is sometimes worse than the crime. I hope that my colleagues in the majority will not enable this manipulation of our court's rulemaking authority in order to permit Justice Weaver to whitewash her improper behavior.
May I speak?
Well, Justice Corrigan certainly has her right to her opinions, even when they're not correct. And I would say the records don't substantiate what she says. For the record, my dissent to the gag order was published and is in the books, but not on our website, where I point out all the flaws of the gag order. I think Justice Corrigan has revealed here that something was sent to the JTs concerning me, and in it, and perhaps Justice Corrigan will want to reveal who sent it, since she's raised it up. Do you want to, Justice Corrigan?
Your choice, Justice.
No, not my choice, your choice. In any case, at this point, I'll come back to that. The fact of the matter is that that made me go back to look at what, if you read what I've written before, the order is unconstitutional. because it was used in 206 to suppress my dissent, which is against the Constitution. Now, it was suppressed for 15 days, and then saner minds decided not to suppress it. It remained in effect until January 17, 2007, when, after I had pointed out that you had to have a public hearing on this matter, that we had the public hearing. What happened is some people came, judges, interestingly enough, who are interested in secrecy, and as opposed to openness, came and testified. And then people from the public came and were outraged at this particular thing. And so what occurred is that when we went back, at that time, we didn't have these nice open discussions about what we're going to decide and vote publicly. So we went back where we talked, and the discussions were quite interesting on both sides. Remember, the vote in 206 was 4-3. Now, what occurred is there was a lot of talk, and finally, our records, after certain people sent a letter to the JTC with my name in it, and also with the gag order in it, and I was notified by these people who did it, who don't want to stand up right now and say they did it. But they're sitting here.
I referred you because you are unethical. You have destroyed the confidentiality of this court. You've revealed our deliberations to a party in a closely related suit that gave them intelligence to support a motion that they filed in this court. You have compromised the integrity of this court and made it impossible to have deliberations without the fear that you, at your whim, will allow people who should not hear what this court is deliberating about, that you will tell them. And it has, in a particular case, compromised this, and I had an ethical obligation to refer it. You've admitted that you did the disclosure, and this is the second documented, admitted breach of the confidence of this court.
Well, here again, Justice Young has every right to his opinion, even though I obviously don't agree